Good afternoon, everybody. It's 2:15, so we will now make a start. Just a couple of things before we begin. I've noticed a couple of new faces around the table. If I could just ask anyone who's new, if you'd just like to introduce yourself and say who you're representing.
Hello, Steve Smith from ACOM, working on a sustainability appraisal for the council.
Chris Pond from Loughton Town Council and also the Loughton Residents Association. David Altris was representing this morning, this afternoon. I'm taking.
Jane Mulcahy from Jam Consult on behalf of Telly Lands Improvement.
Again, just before we move on to issue 3, just two things. Would the council perhaps be able to arrange for a copy of that judgment that was mentioned earlier, the drop-in to get to me via Louise and also onto the library? That'd be useful. Thank you. And Mr. Mills, I think just asked me if he could briefly make a point of clarification this morning. So do that first.
Thank you. It's mainly a question. From behind me, it was. From CK Properties, it was heard that the council said that every emission site got contacted regarding a meeting for the reasons why their site had been omitted. And I was wondering if that could be confirmed or clarified, because that, as I understand, on my instructions, that wasn't CK Properties' position or understanding.
Just to clarify, that was all emission sites from the Regulation 18 draft local plan.
Okay, thank you. So we'll move on to issue 3. So we have issue 3 to discuss this afternoon in terms of programming. Issue 4 concerning.
Mum, before you move off that point, in terms of the consultation that was undertaken at the Regulation 18 stage. There were meetings held with people who were proposing sites, but it wasn't in the meeting. In the case of my clients, the meeting was not concerning the emission site, it was concerning a different site. And I would like to put before you the correspondence relating to that, the meeting note and the correspondence, to explain that, because it's an ongoing issue with my client. Is the council have perpetually looked at the wrong site. So again, at that meeting, clear evidence the council were assessing the wrong site. If I can put that forward. Thank you.
We're going to move on to issue 3 now. As I say, just for programming for this afternoon, so we need to look at issue 3, the duty to cooperate, issue 4 about the sustainability appraisal, issue 5 I've deferred until the 21st of May. Issue 6 is about climate change, and I'll just make it clear now that I don't have any further questions about that unless anybody wants to raise any specific concerns. And issue 7 is sort of some issues about superseded policies and mapping, about which I have some very specific questions. So the two sort of more lengthy items are issue 3 and issue 4. Now, I intend to try to take a break at around 3:30, and I think it would be helpful to the scheduling if we were finished with issue 3 by then. Obviously, if we can't be, then that's fair enough. But that's where I'd like to be in terms of programming, to finish that before the break and then move on to issue 4. So if you do your best to help me with that, I'd be grateful. So we'll begin with issue 3. Has the duty to cooperate, as required by section 33A of the Planning and Compulsory Purchase Act, been met? And obviously my questions here have derived largely from what's come from statements as new points or points where there are still things to resolve. So the first point to discuss is cooperation in relation to transport infrastructure and service provision to support the Harlow and Gilston Garden Town prior to the submission of the plan. And what I intend to do, I think, this afternoon is there's been lots of points of crossover. I'll set out what my questions are and then go around and you can direct your answers to those as far as possible. So my first question is that section 33A requires engagement constructively, actively and on an ongoing basis during the preparation of development plan documents. And the council statement has explained quite carefully the joint work that has been done or commissioned by the boards as a result of a budget agreed in January 18. yet the plan was ready to be submitted not very long after that, in March 18. So perhaps if you could tell me a little bit more about what cooperation took place in relation to these matters, including transport studies and modelling, air quality monitoring, during the preparation of the plan up until submission, and how it's informed the proposals.
Thank you. The Cooperation for Sustainable Development Member Board preceded the establishment of the Garden Town Member Board. That's been in operation since 2014. And the authorities that now make up the Garden Town were part of that member board, together with Uttersford District Council as well. Through that body, we've cooperated on any strategic cross-boundary matters, including transport and infrastructure and service provision. And that led to the four memorandum of understanding that were signed by the parties prior to the pre-submission plan going through full council. Indeed, they were signed in the lead up to the East Herts district local plan examination. In terms of the Harlow and Gilston Garden Town, the Garden Town wasn't designated until January 2017 by the Ministry of Housing and Local Government. And following that, a member and officer group were also established for that body. And a number of joint projects have been undertaken since then in relation to transport infrastructure and service provision. These include a sustainable transport corridor study, which has just been published on our website. On the back of the Epping Forest Special Area Conservation Memorandum of Understanding with Natural England, we've undertaken further air quality monitoring work, which has led to an interim recreational strategy and will lead to a strategy to deal with air quality aspects in due course. We've undertaken some more strategic transport modelling. There was a lot of modelling work done to inform the strategic options around Harlow prior to that, and I'm sure we'll cover that in the sustainability appraisal session next. There was a lot of option work done around what were the best options for sites in and around Harlow to meet the overall housing need within the HMA, which informed the selection of the sites around Harlow. We've undertaken a water cycle study, and more recently we're now preparing a joint infrastructure delivery plan with the Garden Town authorities. So the five authorities are the two counties, Essex and Hertfordshire County Council, together with Epping Forest District Council, Harlow and East Herts District Council. We're also undertaking viability work to support the joint infrastructure plan, and the plan will cover transport, education, health, community facilities, open space, utilities and waste facilities and stewardship. So very much building on TCPA Garden City principles in terms of bringing forward growth in and around Harlow. Since April 2018, there are 13 different work streams which have been set up, which are made up of officers from the five authorities and the Garden Town team to progress aspects and to take forward the work of the Garden Town, and indeed to ensure that we can have timely delivery of the sites and bring forward the growth required together with the necessary infrastructure.
Just on that point, you say that since April 2018 there have been sort of these 13 work streams. Obviously we might return to it under matter 8, which talks about the Garden Town specifically, but if the IDP for the Garden Town isn't yet finished, and it's been sort of ongoing since the April, is the plan itself as submitted based on sufficient evidence that it's viable and deliverable? Should any of that work been ongoing before the submission of the plan?
The three district councils had their own infrastructure delivery plans to support their local plans, and they looked at the overall infrastructure needs of the sites being proposed, and indeed the infrastructure requirements. So we're very much relying on those, recognising that we need to join them up and do some more detailed work.
Just to supplement that, the initial IDP work that was undertaken for this district was undertaken in collaboration with Harlow District. So whilst the IDPs were undertaken as separate reports, there was a considerable amount of collaboration and discussion between the appointed consultants to ensure that there was a coordinated approach taken.
Does anybody else around the table want to raise anything in relation to this matter? No?
So are we? Sorry.
Sorry.
Are we dealing here just with the Harlow point, or with wider cross-boundary issues?
My specific question that I had as arising out of the statements concerned Harlow. So and the Garden Town situation, if we deal with that first, if no one has anything else to say about that, then I'm quite happy to take any other points that you might like to make.
It's other, so thank
It's
you.
other. Okay, so is there anything more on the Garden Towns? Mr. Hill.
Just concerned that if there is any more information you would like that would assist you in relation to what happened prior to the submission of the plan, then please let the parties know. Obviously, my clients own and control the vast majority of the site to the south of Harlow, and we've certainly been involved for many, many years in providing information to assist in the planning of the Garden Town. But I detected from your the point as you have raised it that perhaps you weren't satisfied that all the information you'd need to assist you and help you reach your conclusions was necessarily available at the moment as part of the examination library. If there is anything, please just let the parties know.
Thank you, Barn. The point is in relation to cross-boundary issues in relation to the forest. We know that obviously the SAC, that's me, try leaning further away, is a critical issue here, and there is, as we've said in the hearing statement, a significant absence of participation on the Forest Memorandum of Understanding, which is a crucial document, as has been mentioned, by two of the key authorities, which the nearby Strategic Planning Authority, the London Mayor, and all of the other authorities are relying on participation by London Borough of Redbridge and London Borough of Waltham Forest. So those two authorities have a critical role in the Forest MOU, which has been referred to, and that's acknowledged in the evidence base in the duty to cooperate MOU and the Statement of Compliance, EB 119. Now, the most that could be said by the time that the plan was ready in the Council's eyes for submission in December 2017 in EB 119 is that London Borough of Waltham Forest and London Borough of Redbridge had been invited to participate on the forest issues. So this is the point where the EB 119 is saying that the plan's fully compliant and ready to be submitted. So they've been invited to participate, but there's nothing further that one can glean from the evidence base. There's no statement of common ground which helps us work out if anything had happened up to that stage, which isn't revealed by the DTC Statement of Compliance. And the position appears to be, well, it is the case, that the Forest MOU, this critical document, those two authorities are not signatories to that document. So we have no MOU, Forest MOU, with those two critical signatories. We don't have their participation on those issues or a duty to cooperate, audit trail, statement of common ground, to inform the examination or participation on the assessment of alternatives to whatever that MOU may give rise to. So my point really is, has there been...
Mr. Pinnock, could you just give me the reference for the MOU that you're referring to? Give me the document number.
The duty to cooperate MOU is... let me just find it. This is the... Do you mean the DTC MOU or the Forest MOU?
The forest, the one that you're concerned about that doesn't have the appropriate signatories. So I'm just trying to be clear about the concern that you have.
Let me just get the reference for
That's
it.
fine, yeah,
But
please.
it is the Forest MOU that they are not signatories to,
Yeah.
the submitted version of it in the EIP library.
EB 1200.
Thank you very much. Apologies.
Thank you.
So the point really is simply, how has there been discharge of the duty to cooperate with those authorities who were sort of invited to cooperate by December? We know that they're on the board, and we know that they've been put on working groups and things like that, but they're not signatories, and as I say, by December 2017 there'd merely been an invitation issued.
And what concerns do you have about their lack of participation? What's the concern that you have about the outcome of that?
There won't be an effective strategy for the forest, because obviously they are identified within the other evidence-based documents as critical participants in mitigation on the SAC. So, for example, the duty to cooperate MOU itself acknowledges that SAC impacts will occur from outside the HMA. So simply pursuing a line where only the HMA authorities are signatories to the Forest MOU is clearly inadequate. I just want to understand when they're going to sign it and where they've got to. And obviously longer term, within this examination process, we need to understand what the relative cost apportionments of that would be and how that affects the viability of allocated sites. But for the time being, because we're only on the duty to cooperate point, it's not clear how that duty has been discharged up to the point of plan submission, where those two bodies had merely been invited to join a group and not had actually done anything to sign the MOU.
Council to come back on that.
I'm not sure I completely understand what the duty to cooperate point is, but both Waltham Forest and Redbridge have been involved in the Cooperation for Sustainable Development Board, both member and officer level. Since we signed the Memorandum of Understanding, we set up an oversight group of officers to take forward the preparation of the mitigation strategy to which both Waltham Forest and Redbridge were involved in meetings. Indeed, Waltham Forest themselves paid the contribution towards doing the visitor survey that we needed to do to look at the recreational impacts on the forest. And we've had ongoing meetings with them and Natural England and the Conservators to try and develop both the recreational strategy and the air quality strategy, which will together make up the mitigation strategy for the forest.
Okay, well, thank you. Obviously, I'll have a look at the MOU that's been discussed about the forest. But if they've been involved all the way through, is there a reason to think that is there any reason to be concerned they haven't been involved in that process, and why would they not have been signatories to it? Perhaps you could just explain. That's obviously the concern that's been raised. Why they haven't signed it if they've been fully engaged in the process?
Or the interim strategy, which is the other thing they're not a participant in approval of, is the interim strategy itself.
Okay.
At the time when the Memorandum of Understanding was being prepared, we prepared it with the housing market authorities, the four core authorities for our strategic housing market area. At the time, the advice was that those were the appropriate authorities. I think lots has happened and developed since that Memorandum of Understanding was signed, and we now have a better understanding of what's required in terms of the competent authorities. I think Waltham Forest and Redbridge are quite clear that they are competent authorities for the purposes of habitat regulations, and are working with Natural England as well to develop what their strategy will be. As many of you will know, the Redbridge plan was examined and met the habitat regs assessment as part of that. So they're in a slightly different position. Waltham Forest are just bringing forward their plan and are just considering the best way to address these issues. There is ongoing work with Natural England and Natural England are satisfied with the progress that we are making. Just to add, we have a list of all the engagement that's taken place back from February 2017, from when the Memorandum of Understanding was signed, and we can provide that if that would be helpful.
Thank you, Ron. I mean, obviously it would be helpful because that's the information, that's the audit trail information that's needed to establish whether there's been compliance with the duty. So I don't understand why there's no statement common ground if between February and December, when the plan was submitted, significant progress was made in correcting the errors in the plan preparation and the duty to cooperate process of not engaging outside the HMA authorities, then it's not clear why that information wasn't provided as part of the duty to cooperate audit trail and the compliance statement. The compliance statement in December simply says on this topic that those authorities had been invited to join. Now, if we're to understand now that there's an audit trail that sits behind that, it suggests that there had been significant substantive discussions and agreements between February, when the position was corrected, and December, when the plan was ready to go, then well, certainly you need to see that, obviously, in our submission. But it still doesn't make any sense that those two authorities are not signatories to any MOU that's been submitted to the CIP, nor are they, as I understand it, signed off and in agreement with the interim strategy itself. And if those are matters that I'm wrong on, then that's great, but let's have them in evidence.
So to deal with that point, the council says it has an audit trail of discussions with those relevant authorities. You can make that reasonably available. Okay, thank you. Thank you. Mr. Bolton.
Thank you. Looking at the duty to cooperate, my point is about whether or not the duty to cooperate has been fulfilled with regard to meeting housing need. Now, I will need to refer you to a couple of points on this.
Before you carry on, obviously the very next heading on my agenda is the duty to cooperate and housing needs.
Oh, sorry.
So we're going to cover that definitely.
I'll shut up.
So if we could just deal with anything else that's not to do with that second issue, then we'll move on to the housing matter. Is there anything else, or shall I let Mr. Bolton continue? No. Okay. If you just briefly let me then, as I said at the beginning, what I'll do is I'll set out my main questions. I'll read them all out so that when you address your points on the housing matter, you know to direct them as far as you can to the issues I have. So first of all, I have on the agenda whether the decision of the HMA authorities not to meet the identified OAN by 600 dwellings is a duty to cooperate or soundness related matter, and then whether the MOU between the HMO authorities amounts to an agreement for the shortfall against the OAN in Epping Forest to be met elsewhere. And essentially that question is Epping Forest relying on other authorities to make up their shortfall? And another issue that has been raised is whether the SHMA of 2017 potentially underestimates housing needs in the HMA, particularly in Harlow, and whether this is a duty to cooperate matter for this or a subsequent plan. So they're the things on the agenda. Now, the key questions I have are: the council's explained that it's undertaken joint working on housing needs since 2008, and the requirement for 51,700 dwellings identified by the SHMA in July 2017 differed from the 51,100 agreed by the HMO authorities in the MOU of March by just 600 dwellings, which amounts to 27 per year for each authority. And the council, again, Mr. Beard, correct me if my interpretation is wrong, but the council has explained that because this represents a very small difference over the 22-year period, officers decided it wasn't necessary to revise that MOU figure. And the council has further explained that the East Herts plan was examined on the basis of that figure, the 51,100 figure. So we will return to the soundness of the housing requirement under matter 3. So I want to focus on the duty to cooperate issues here rather than what the numbers themselves should be. But some participants have suggested that the HMA authorities had a duty to revise the MOU to ensure that the OAN was met. And they suggest that the duty to cooperate cannot be met simply because the authorities agreed to meet the OAN without first exploring whether they could. So my first question is, should this have been done? Should duty to cooperate discussions and things have taken place to see if you could raise the requirement to meet the OAN, even for the sake of just 600 dwellings? That's the first question. And then, is the duty to cooperate relevant in respect to the criticism that Epping Forest itself should have raised its own requirements? Should it have sought help from the other HMA authorities to meet its own requirement? So I'll leave that there, and then I can take something from the council to start with, and then I'll go to Mr. Bolton.
Thank you, Madam. It's not true to say it was just an officer decision. It went to the Co-op Member Board in July 2017 to discuss whether or not there should be a revision to the MOU to take account of the revised figure. The view of the Member Board was that the number could be accommodated within the proposed allocations within each of the 4 constituent authorities, and that therefore there was no need to revisit the MOU. At that time, East Herts were about to go to examination, and so it was a critical matter clearly for them. But there was a very clear discussion and agreement not to change it because we felt that it could be accommodated. In terms of whether or not we asked other authorities, yes, we did write round to other authorities to see whether or not there was potential for them to accommodate any additional housing need. And the answer was no.
So just to clarify before we move on, is it the council's position that the HMA authorities didn't take a decision sort of not to meet the OAN? It was you felt it wasn't necessary to revise it because the OAN, given it was only 600 dwellings overall, would be met, and so it wasn't necessary to revisit the process. Is that correct?
Yes, indeed.
Anybody else? Mr. Bolton.
Thank you. Dealing, if you like, with your questions, the duty to cooperate statement, EB 119, paragraph 3.10, refers back to the Memorandum of Understanding, which commits all 4 councils to meet their individual housing needs within their own administrative areas. So therefore, the agreement that you refer to about no one wanting to revisit that statement is fine for the other councils because it's effectively Epping Forest which is under-providing, not them. They've already said, as you've heard, they've said that they can't meet any of Epping Forest's needs, so the 514 as opposed to the higher figure, which is not being met, is just going towards increasing demand for housing generally and increasing rates of affordability in the area. So in that respect, if you like, it's this council that's not performing to its own duty to cooperate statement, meaning that it's under-providing, it's not meeting its needs. The duty to cooperate statement makes no discussion of how the higher requirements in the 2014 base projections are going to be dealt with. It's dependent upon, if you like, the earlier work. And the duty to cooperate statement does not commit the LPAs to deliver the level of housing in the spatial option. That's EB 1202, figure 5. So in a way, the duty to cooperate doesn't quite do what it's meant to do. Moving on from that, and I realise this is slightly technical, but it is important, is the construction of the new figure, if you like, how the wizardry that's been applied to keep the figure for Epping Forest, the housing figure, down, is quite important. And if you just take notes of the paragraphs, and we'll come back to them when we discuss matter 3, and I won't go into detail, it's just the general that I'm setting out. In simple terms, what the most recent assessment of objective assessed need is, it's taken by looking at the official projections and then reducing them down due to different assumptions made about migration. That gets you a baseline figure. Then what happens is they use the Greater London Authority projections, called the central projections, to calculate the additional dwellings that might be required coming out of London. That produces an uplift for the HMA of some 6,200. What is then done is that 6,200 isn't distributed between the local authorities on the basis of the Greater London Authority projections, which is what one would assume one would do. You're using those to, if you like, estimate the overall number for the HMA as a whole. It's not done according to those projections at district level. It's pro-rated out, and that gives you a very different distribution of housing need compared to what the actual baseline projections would require. To me, that's a policy on process. In other words, to get the number down to the one that's being promoted to you, which is a 580 a year. There's been a pro rata distribution, if you like, of the additional housing coming out of London. That's how it's described effectively. And that is a policy on approach. Now, the correct approach would be to have a policy off approach, I think. Now, we'll come and debate that in a great deal of detail later. But if I'm right about that, then the impact is that, in effect, the adjustments that are being made in order to secure or put forward the level of housing in the plan at the present time, the 518, that's explained on table 7, page 12 of my matter 3.
Sorry, Mr. Bolton, just to pause there. Are you able to bring it round to the sort of the duty to cooperate issue?
Yeah, I'll do that. Yes.
Thank you.
If you look at if you make a note of the table 7, page 12 of my matter 3, what that highlights is that some 1,547 dwellings have effectively been reallocated to other authorities within the HMA. Now, that is something that, if that's what's happening, then the duty to cooperate statement is factually incorrect. They're not meeting their own needs. They are actually reallocating it. Now, that needs to be in the duty to cooperate statement. That's what those statements are for. It's not to hide the fact. It's to actually accept that that's what they're doing, and it doesn't appear to do that. So the duty to cooperate statement is, in my mind, factually incorrect because of this policy on reallocation of demand at the housing market area.
Just to make sure my understanding is clear, so you're saying that the duty to cooperate statement commits the councils to meeting its own needs, is that right? And that obviously this council doesn't.
In a nutshell, yes.
Okay, and so that's where that's the failing of the duty to cooperate that you're
correct.
That you're alleging. Okay, could I just ask the council to respond on that specific point? I mean, is there a requirement with anything that you've agreed in your duty to cooperate workings that each council must make provision for its own requirements? perhaps compare this. I'm reading, and just put this out to everybody else around the table as well, looking to the NPPF, paragraph 47. It says here that local planning authorities should use their evidence base to ensure that their local plan meets the full objectively assessed needs for market and affordable housing in the housing market area. So obviously that's what national policy is saying. Obviously there's this issue about the difference between the 600 dwellings. But the council's point is that would be absorbed. So is there a failing of the duty to cooperate? I guess is the question. If this council in particular doesn't meet its own requirements, provided that the requirement is met within the HMA. I think that's the key question in my mind. If you could help me with that.
We would say that we've complied with that requirement.
Thank you, Ma'am. I think the point being made here is a very simple point. It's not a run of what should the housing figure be. That's for a different day. It's about whether or not the council have cooperated. And on the face of it, a reasonable person would say, blimey, they've done ever such a lot of cooperation. They've got all of these joint committees. They've done all of these things. Surely they've satisfied the duty to cooperate. And forgive me, Ma'am, but I go to a lot of these local planning inquiries, and I usually have an argument about how the duty to cooperate is not a duty to agree, and that's, thrown out at this stage. That isn't what we're arguing here. What we're trying to stop is a duty to conspire rather than a duty to cooperate, and that's what the councils have done here. They are to be commended for the amount of cooperation that they have undertaken, but of course it hides the fact that what they have undertaken is a conspiracy. They've undertaken a conspiracy to all come together and deliver what they know to be a figure which is below the objective assessment of need, even using their own measures. And you might say, it doesn't matter, it's only 600 units over an entire HMA, it'll all come out in the wash. I guarantee you, Ma'am, that those 600 houses will never appear in anybody's calculation for their 5-year housing land supply. It'll never appear in anybody's calculation for their housing delivery test, because the figure that will be used will be the figure that is adopted in the local plan, and therefore not a house more will be delivered, because that's the kind of councils we're dealing with in this area. So they will not come out in the wash. So it's exceedingly important that they do meet their objective assessment of housing need. And we have also therefore look at para 33A of the Planning and Compulsory Purchase Act, and what's the point of the duty to cooperate? And the point of the duty to cooperate, it quite specifically says that bodies must cooperate with every other person as defined. So, these people who must cooperate. It says in maximising the effectiveness of that duty. Maximising the effectiveness of that duty. Not trying to hide houses, not trying to duck their responsibility of bringing forward the needed development in those areas. And yet we have seen that this conspiracy, the duty to conspire, has done exactly that in this area. I have never seen a more blatant appraisal of what the 4 councils are trying to do in terms of saying, we'll meet this figure because this figure is one heck of a lot lower than the figure that we know is coming down the rails. Now, that's not concerning you, because that's for next time around. But we'll be sitting here for 5 years planning for a housing figure which is way below housing needs, because this council has conspired, not cooperated with the adjoining authorities to meet housing needs over the next 20 years. That is a failure and indeed an abuse of the duty to cooperate.
Thank you. I'll let the council come back on that before we move on.
It's true to say that the MOU that was signed was for 51,100 dwellings. Of that share, the East Herts district plan were due to provide 18,000 dwellings within their district, whereas their recently adopted plan already provides for 18,458 homes. So that alone represents over 3/4 of the 600 dwelling so-called unmet need for the entire HMA, as we have set out in our council's matter statement. The MOU identifies the housing requirement for this district as 11,400, and as you will have read, the plan provides in excess of that requirement. So that's a minimum, and to say that we won't deliver the extra 600 dwellings is not true.
Thank you very much. I can see on the agenda there are 3 sort of arrowed sub-questions, and I had thought we were dealing with 1 and 2 of those, but then something which I'm planning to deal with in question 3 has just come up. So I was wondering what you want me to deal with now, because I have something to say about all of them.
There's only 1 left. I'll forgive you. You can deal with all of them now. That's fine. That's
okay. I apologise.
I think it's just arrow 3. Arrow 3 is about whether there's an underestimation of need and whether that's an issue for this plan or a subsequent plan. We've heard from the HBF about the sort of larger housing numbers that might come up in the future being an issue perhaps for a later plan. So it's interrelated really. So make your points now.
Well, I apologise if I'm then speaking for a longer continuous chunk than I thought I might be. But I'll take them in turn then. So question 1 of those 3 arrowed questions are whether or not this is a matter which should go to soundness or legality. And in my submission, the extent of cooperation can, of course, go to soundness, distinctly from the question of legality and whether the plan should fail. The forum suggests that or the forum's position is that it does not want this plan to fail and go back to square one, but rather it requires MMs to ensure that it's made sound. However, the depth of the engagement with other authorities, particularly the London authorities, can be relevant to soundness and is relevant to the question of soundness. Now, the advantage of taking that approach is that if you find this as a matter of soundness, then it can be dealt with by MMs rather than just finding that there's an irremediable breach of the duty to cooperate. Comment which was made by the council, I confess, piqued my interest in terms of the 600 dwellings shortfall from the MOU. It being decided that there didn't need to be a further MOU or what have you to agree with that. Now, it was said that that was dealt with at member level. Now, that piqued my interest because paragraph 37 of the council's Matter 1 statement says that it refers to the officer group agreeing this. So it might be that if the council's position is that this was agreed by members, you might want to see some evidence of that, because that, as far as I can see, that isn't what's said in their recent written case. On the point of soundness and legality and cooperation, just because the forum is saying now that this should be seen through the lens of soundness, that doesn't mean that there can't be legal errors in relation to cooperation. And there are 2 concerns which I'm going to raise now, which arise from the council's statement. Firstly, the council seems to rely on the terms of reference for the Cooperation for Sustainable Development Board, having been recently amended. Now, in my submission, that's absolutely nothing to the point. The fact that a body's had their terms of reference amended, that has nothing to say whether or not they've done anything or cooperated. The question is what was actually done after the 2017 SHMA and the update to that. The second point, and to my mind this is a fundamental one arising from the 600 dwellings point, is that it seems to be asserted by the council that there's some sort of proportionality threshold in terms of the duty to cooperate, whether that's seen through the lens of soundness or section 33A and the possibility of the plan not complying with the legal requirements. Now, in my submission, saying that there is a proportionality test in saying whether you have to cooperate, that simply would be an error of law if that approach was taken. There's nothing said in that respect in the legislative text, and that is not the basis on which the council or indeed this examination should proceed. But I would stress that in any event 600 homes isn't de minimis. For instance, for a single development that would be substantial. And if it's now said that the need can be accommodated, so as I understand that the council's defence of this point is in part that the HMA group were satisfied that need could be accommodated, then why is that not reflected in Epping's plan? And also, we're told that Epping went to other authorities to ask whether those other authorities could meet Epping's need, and they were told the answer was no. So I don't quite understand how those 2 points are consistent. That might be something which the council is able to assist you with. That was my first arrow question, and the second one is about whether there's an agreement for the shortfall to be met elsewhere. The fundamental point is to look at what the MOU says. So this is EB 1202, and that's paragraph 2.4 numeral 1, which indicates that this is an MOU which reflects an agreement to meet the figures in the 2015 SHMA. It isn't an agreement, as I understand it, that whatever might turn out to be assessed as the HMA's need, in due course, that would be met. And then the 2016 SHMA came out, and the HMA considered that they couldn't meet those figures, and so the parties sought to stop the clock. And in my submission, that approach doesn't reflect the fact that this duty, this cooperation should be ongoing. Ma'am, you already have in mind that the agreement in the MOU is not to meet the OAN figure as comes out of the 2017 SHMA. And I would make the point that yes, this is about maximising effectiveness of the planning document, and as a matter of government policy, there should be an aim towards the OAN. An agreement to fail to meet that OAN, if it could ever be lawful, that would require the strongest justification, which, in my submission, isn't made out. So that was the second point. The third point concerns the SHMA potentially underestimating housing needs. Now, as no doubt you've seen, Mum, there are detailed submissions. There's detailed evidence from the forum on this, which will go to matter 3, and particularly a lengthy appendix from RPS in relation to that. And I'm not going to speak to the details of the numbers now. What I do say is that the statement regarding the duty to cooperate is glaring in terms of its lack of cooperation for housing need from London. And in terms of some references concerning the connection between Epping Forest and London, for your note, Ma'am, the sustainability appraisal at EB 204, Appendix 2, page 92. The SHMA, EB 405, paragraph 2.24, paragraph 2.71, paragraph 2.75, which concerns maintaining dialogue, and paragraph 5.60. Now, if one looks at EB 119, the duty to cooperate statement, that is clear that cooperation regarding housing is cooperation within the HMA, not outside it. That is the approach which the council has taken, and you can see that in paragraph 3.8 and following. And you can contrast that with the position regarding transport, paragraph 3.15 of that document. Now, the council's response has been to say, well, we weren't asked by neighbouring London boroughs to meet their unmet need. Now, in my submission, that's clearly not enough to say, oh, well, no one contacted us. That's clearly not enough to meet the requirement of soundness. For instance, the requirement that a plan be positively prepared. And that is as clear an example as you can see of passive preparation. No one contacted us. In terms of East Herts, the council relied on East Herts in its written statement and also just now. I would make the observation that the East Herts figure has increased, and my understanding is that was an increase post-submission of the East Herts plan. So the only plan in the HMA to have gone through examination has increased its housing need figure. Ma'am, you may wish to consider the examining inspector's report into the East Herts plan, and specifically paragraph 29. The point which has been made made previously at paragraph 35 of the Council's Matter 1 statement and repeated just now is essentially that you can subtract from the 600 unit shortfall that 458 uplift by East Hertfordshire. So you're left with much less. But in my submission, you can't simply do that subtraction exercise because East Herts' figure was based on a view that there was an increased need figure. So if that is correct, you can't simply do that subtraction. And in any event, in terms of positive preparation, it is not enough to say that a neighbouring authority happens to have taken on more development. It was lucky East Herts has taken on more houses. That doesn't indicate positive preparation. It's also said by the council that objectively assessed need is not an exact science. And if I understand it, that point is being made, oh, well, objectively assessed need is not an exact science, so we don't need to worry that much if we don't meet it. Now, that's simply a non sequitur. Prior to the new standard methodology, which this plan isn't being examined under, it is true that there isn't a single means of calculating OAN. And what that means is that legally, you can't say that just because there's another way of calculating OAN, that the way which was used was wrong. That's what that means. But it doesn't follow from that if the council, if a local planning authority selects an OAN figure, it can then say, oh, well, that OAN figure is unimportant because there are multiple ways of calculating the OAN figure. The fact that it's not an exact science doesn't mean that OAN is not significant. It clearly is an important matter in national planning policy. Then finally, the point as to whether an underestimate in the SHMA is a matter for this plan or a matter for a subsequent plan. In my submission, every plan needs to be robust, and if you are satisfied that the housing needs are not met, and of course you're going to come to that evidence more in due course on Thursday, then that plan isn't sound, and then the obligation to make the recommendations to make it sound kicks in. The plan must be justified, and the most appropriate strategy must be taken in relation to the plan. And simply in terms of housing and the clear need for housing in Epping, the can shouldn't be kicked down the road even further. Thank you. I'll finally stop talking. Thanks.
you, ma'am. I can be quite brief, and I'm going to confine my contributions to answering your three arrowed points at the top of page 3 of the agenda. First of those, whether the decision of the HMA authorities not to meet the identified OAN by 600 dwellings is duty to cooperate or soundness-related matter seems to us, at least, to be quite a narrow point, and you're not inviting an extensive airing of the material on housing need there. It seems to us that it is a soundness point rather than a duty to cooperate one, and that no Section 33A legal failing is disclosed. It's also clear from what we've heard that the HMA authorities discussed what to do and resolved a particular course of action. So there was cooperation underlying their action in that regard. As to the substance of what happened, we are talking about 600 units, 1% of the HMA OAN. And again, as we understand the position, although we haven't looked into it in a great deal of detail, the East Herts plan as adopted adds 458 units from the 600 apparent shortfall. Second point, ma'am, whether the memorandum of understanding between the HMA authorities amounts to an agreement for the shortfall against the OAN in Epping Forest to be met elsewhere. It is certainly, as we understand it, a consequence of the cooperation within the HMA that other authorities pick up some of Epping Forest slack. That's certainly the way we understand it. So that the need in the HMA overall ends up being addressed, as you rightly drew to our attention, in accordance with paragraph 47 of the 2012 framework. And then third and last, whether the SHMA 2017 potentially underestimates housing needs in the HMA, particularly Harlow. Potentially that is the case, but again, this seems to us to be an issue that maybe we might want to explore in more detail later on in the examination. But what we do note, as we understand the figures, is that Harlow seems to be planning, pursuant to the Memorandum of Understanding, for 9,200 units, which is some way in excess of the SHMA 2017 figure of 7,400. And so far as we're aware, again, the latest demographic material doesn't seem to suggest a major upward revision for Harlow. But again, I'm sure you'll come back to that when you look at OAN in more detail in a further session of the examination. Thank you, ma'am.
Mr. Pennock.
Well, it stands between us in the next session, so I'll be very brief. It was just to pick up on the points that have been made by Mr. Whittaker and Mr. Mills in relation to if there's an arbitrary nature of the OAN cap that's been set at the HMA level, then does that infect the duty to cooperate point? I'm sure the council will respond on that if you think it's appropriate. But the issue from our side of the table is really just that the 51,100 HMA figure that is selected, when you look at the SA evidence base, and I'm thinking of the spatial options report, that's EB 203, it says, bold as brass at paragraph 4.2 on page 34. There's no sort of sub-paragraph numbering, so it's a bit tricky, but it's page 34 has inked at the bottom of the page, that the OAN number simply reflects the furthest the authorities consider they can reasonably go in delivering the most recent advice from ORS, which was actually at that point, it was the lower figure, regarding housing needed in light of the available evidence. But none of it explains why that was the furthest they could go. Obviously, the whole purpose of SA is that it does explain why that's the furthest they could go. And then it just says elsewhere that, it simply quotes good progress towards, quotes, the revised OAN figure. So I think that goes to the point about whether this is an arbitrary OAN figure. And if it is, then my understanding of submissions made is that there's a decision to be made about whether that infects the compliance with the duty.
Yes, and pose a question which hopefully will clarify the role of the of what the duty to cooperate actually means. Firstly, it is difficult to assess OAM figures, but they are minimum figures, so they should be met, and they should be planned to be met, is my first point, and with the answer to whether 600 dwellings matter. To us sitting around the table, probably not. To the 600 people who might inhabit them in the future, probably do. So yes, they do matter, and I think they matter in terms of planning framework as well. In terms of whether or not the other authorities are going to meet Epping's Forest needs. Now, we're going to have an interesting debate, I think, in terms of what Epping's Forest needs are. But I suppose the question to the council is, if as a result of that debate you come to the conclusion that the objectively assessed need is higher, is it something they can go back and do a new search for sites like Welland and Hatfield have done? You know, can they turn over a few more stones? Or have they done absolutely everything they can to find every last site at this stage? Because personally, I don't think they have, looking at the evidence base, the mistakes they've made in the evidence base, the failure to consider some sites. But does the duty to cooperate require them to go and try and find additional sites? Or are they going to go and ask the people outside, the other people in the HMA? Lastly, in terms of whether the HMA is underestimated need, in very simple terms, the Greater London Authority projections that are being used as a baseline, if you like, for this, have a requirement of about 49,700. What the council have done for the HMA as a whole is applied a 2% uplift for affordability. Now, that I think it will come out quite clearly is not enough in terms of for the whole HMA. So I think the answer to that is yes, clearly the level for the HMA is higher. But I would appreciate the answer to the question in terms of what would the council do if the OAN comes out high.
Thank you. Just two brief points for me to just seek some clarification from the council, then we'll move on. So I think that perhaps one of the key issues that's come up is, does your sort of decision that you took not to raise the OAN from 51,100 to 700, if you have evidence that that's a member decision, there's some reasoning behind it, I think that would be useful. Because my question, I suppose, to you is, does that decision amount to cooperation to reach an agreed position, rather than just deciding not to do anything, if you like?
Absolutely, it amounts to cooperation, and the four authorities have cooperated throughout in terms of commissioning the work, determining what should happen, and understanding the spatial distribution between the four authorities. What I would add is that our plan provides for more than the 11,400. So the shortfall, together with what's in the East Herts District Plan, isn't a shortfall. We did ask other authorities as to whether or not they could accommodate some of our needs in order to reduce our numbers. As they said no, we met our need. That was obviously to meet the council's strategy to minimise the take of Greenbelt land.
Thank you. If you have evidence of that member decision, as opposed, because I mean, someone else raised the same point. I think your statement does refer to officers having decided. That would be helpful. Thank you. I think I have what I need. If there's no further points, it might be a useful time to have a short break, and then we'll come back to discuss issue 4. Is everybody content? Okay. So we have 15 minutes again until 25 to. Thank you. Okay, thank you everybody. It's 3:35. The hearing's resumed. So we're going to discuss issue 4 now, which is, has the plan been informed by an adequate process of sustainability appraisal? Have the requirements of the SEA directive and the regulations been met? And I want to split the discussion into two areas. The first one being the role of the SA in determining the quantity and distribution of development. And then once we've done that, the role of the SA in deciding between potential site allocations. So starting with the quantity and distribution of development, I think it's been put to me in quite a few of the statements and the representations that the proposal to deliver around 51,000 homes across the HMA and 11,400 in Epping Forest was not arrived at necessarily by an independent and robust SA process, but was rather predetermined by being the preferred spatial strategy, the preferred option of the Cooperation for Sustainable Development Board. So I want to make sure that I understand the decision-making process correctly. So the first two arrowed points that you've got on my agenda concern the HMA level first. So if we could deal with the HMA level first as far as possible and then move on to the Epping Forest specific level. So the two key things I want to understand at the HMA level are whether the option of meeting the full OAN for housing across the HMA, from which I'm taking this as the 2017 SHMA figure, to avoid confusion, was that tested through SA, and whether the preferred option of accommodating 51,100 dwellings across the HMA is supported by the findings of the SA. So they're my key questions. So if we could perhaps hear from the council first of all, and then we'll take other points around the table.
And Mr. Smith from AECOM will help us.
Thank you. Madam, in reference to your first question, whether the option of meeting the full OAN for housing across the HMA as a whole was tested through SA, I'm assuming here the full OAN figure referred to here is 51,710, which is the figure from the SHMA 2017. It's important to understand the chronology of events here, that when the optioneering work undertaken by the Co-op Board for Sustainable Development work was undertaken, we were working to a figure of 46,100 from the SHMA 2014. However, if I could refer you to page 4 of EB 203 from the examination library, that's page 4 of EB 203. This shows that an option of providing up to 57,400 new homes across the HMA was tested through sustainability appraisal. And that figure of 57,400 is obviously of a magnitude certainly greater than the figure of 51,710. So a figure equal to or greater than the OAN was definitely tested.
And where did that 57,000 figure come from? Why was that the upper end?
So by way of further background, as part of the work of the Co-op Board, a sustainability appraisal was undertaken of options for the level and spatial distribution of growth across the HMA, and that work is set out in EB 203. Those options, of which there were 6, were also subject to transport modelling, habitat regulations assessment work. Those 6 options were appraised in 2016. Obviously, this process dates back. Obviously, it's a story we're telling. And we considered 3 levels of growth: 46,100 new homes in line with the SHMA figure from 2015, 49,638 homes or thereabouts in line with the DCLG 2012 household projections, and 57,400 new homes in line with what was the advice from ORS, the SHMA consultants at that time, which took into account the DCLG 2014 based household projections. That 57,400 figure was later revised down to the 51,710 figure that is in the SHMA 2017. If you'd like to refer to the options themselves within EB 203, they are set out. I'll just check the page number. From page 4 onwards.
Okay, thank you. So before I move on to ask for other people's views on that, perhaps you could help me with why the 51,100 was arrived at as the preferred option from those that were tested.
So, as I say, this process of optioneering took place over more than a year or so, and the 6 spatial options, which are set out in EB 203 from page 4 onwards, were tested through various means: a sustainability appraisal, which is documented in EB 203, detailed transport modelling by Essex County Council and Hertfordshire County Council, and also habitat regulations assessment work. The ultimate preferred option, which is the set of figures set out in the signed MOU on housing distribution within the HMA, represents a hybrid of those 6 options, and EB 203 explains why that option was developed and chosen by the partners. The rationale for their choice of preferred option is, I'll just check the page number, is set out on page 25 onwards.
Thank you. Just for completeness and for my own understanding, so did the SA then specifically consider the 51,100 option and assess how that performed against the others?
Yes. So if I could refer you to page 29 of EB 203, you will see there the spatial option as set out in the Memorandum of Understanding in comparison with the other options considered.
And for clarity, as we're sitting here, a summary of the findings in relation to how did it perform? You can just tell me how.
So just to clarify, from our point of view, sustainability appraisal is there to weigh up the pros and cons of different options rather than necessarily identify a favoured option. But as you'll see on section 4.3 of EB 203 on page 34, sets out the Co-op Board's rationale for choosing the preferred option as set out in the MOU, which talks at the beginning about 51,000 new homes being considerably higher than the Shamar figure as it was then of 46,100 homes, which indicated the HMA was planning positively for housing need, and obviously the overall figure of 57,710, which was the ultimate OAN, is closely reflected by the 51,100 figure. So the authorities anticipated well what the ultimate housing need would be. There's then a discussion of the fact that Harlow represents the most sustainable location within the HMA at which to concentrate development. It's already been discussed earlier that Harlow is meeting a higher proportion of housing need than its OAN. I think it's 9,200 versus 7,000 and something. So they're going beyond their OAN because of their economic regeneration aspirations, their position on the London Stansted Cambridge corridor, the enterprise zone status. This was before the Garden Town was awarded chronologically, just to clarify. Very importantly, the transport modelling undertaken by Essex County Council and Hertfordshire County Council indicated that growth of between 14,000 and 17,000 new homes in and around Harlow could be accommodated, provided that the mitigation measures set out in the MOU on highways and transportation infrastructure was delivered during the planned period. However, the evidence suggested that growth beyond 2033 was only likely to be possible with delivery of additional strategic highway mitigation measures. So that 14 to 17,000 range was considered the maximum that Harlow could conceivably accommodate transport-wise. That's EB 1201, the transport MOU. It's also important to point out that This 51,100 figure was obviously based on a lot of bottom-up evidence gathering on the part of the 4 authorities and their partners, including a strategic site assessment which looked at all the conceivable strategic sites in and around Harlow, and it was concluded that a figure of around 16,100 could be delivered on the basis of the most suitable sites. Thank you.
Okay, and take some points around the table. Sorry, I can't quite read your name from there, Miss. Thank you.
Thank you. I just have a quick point, really, with regard to the fact that AECOM say it was assessed in the essay of the spatial options. Because if you turn to page 3 of EB 203, it states quite clearly, it should be noted that the essay was not undertaken in line with the requirements prescribed by the environmental assessment of plans and programmes and regulations. It's not a formal essay. And if you go further to the conclusions of the report, it says this study provides an appropriate strategic basis for the more localised options, in brackets, reasonable alternatives, to be explored through the sustainability appraisals for the local plans. It hasn't been assessed in Epping's local plan. This essay isn't a formal essay. It uses a different sustainability appraisal framework to Epping's. For example, air quality isn't included, a very important issue for Epping. It hasn't assessed the significance criteria set out in Schedule 1 and 2 of the regulations, in particular duration, permanence, cumulative impacts, mitigation measures. It therefore cannot be said that a proper essay has been undertaken. Thank you.
Perhaps before we move on, are you making a related point? Because that's something that would be useful for me to.
Yes, ma'am. It is a related point. I mean, you asked 3 questions in terms of why was the 51100 selected, how was the hybrid tested, and how did it perform? And I just didn't get and sort of perceive an answer to those, in the sense that, as Ms Mulhenny said, the 6 options were tested in sustainability appraisal via a document that stated not to be a sustainability or an SEA compliant document. The hybrid is not tested, it's stated. You were given reference to paragraph 29, to page 29 of that document. And then in terms of how did it perform, I didn't have an answer noted because I didn't sort of think there was one, but you can't tell, which I think is the point, which is why this document says it's got to be deferred, the scoring, both of the 6 options, although, as you know from our hearing statement and our Reg 19 submissions, the 6 options themselves are entirely too limited. But the issue of, well, you know, how did you test the hybrid? How did it actually perform against the others? Why had you stopped there? This kind of finger in the air point that I'd raised earlier on in terms of the furthest we can go. Here we have no evidence to actually explain that in strategic environmental assessment terms. And in any event, it's a document which parks it and says, well, you know, this is not SEA compliant, it's got to be dealt with later, and it hasn't been dealt with later.
Could you address the specific point that's been raised about the status of that document and whether or not it is compliant with the SEA directive?
Yes, of course. I think it's very important to understand that the SEA directive applies to plans and programmes, which have a strict legal definition under the directive. The work of the Co-op Board does not generate a plan or programme in a statutory sense. So there is no conceivability of applying the SEA directive to the work of the Co-op Board unless that work had been a formalised joint local plan. Of course, those didn't exist to the same degree as they perhaps do now. So it's a moot point in a sense. You can't apply a statutory process to a non-statutory decision-making sort of a process, as it were.
If I may say so, Mahmet, it's more than a moot point because it's the question you asked, which is how were the 6 options assessed for the purpose of this session in your question, which is SA and SEA, and how was the hybrid assessed, etc. So if the answer is they weren't assessed because the tier that they were done at isn't a tier which SEA would ever have been conducted at, then we're still left with the answer that they haven't been evaluated, which is a common issue that's been raised around the table in various submissions. It's not possible to intelligibly understand how those options perform, why they were selected, what the hybrid actually performed as, because it was done at a higher level where no SEA analysis was undertaken. That's exactly the point.
I think it's important to point out the test here is whether a legally compliant SEA process has been undertaken for the Epping Forest District Local Plan, and yes, it has. So in relation to EB 204, which is the SA report, at Appendix 1, page 81, that sets out the legal compliance checklist in relation to the SEA directive and the implementing regulations. There's absolutely no doubt the Epping Forest District Local Plan has undergone a legally compliant SA and SEA. Of course, any duty to cooperate work amongst any local authorities will inevitably generate evidence studies. This evidence study for the optioneering was labelled an SA because it was, in essence, an SA because we were looking at the performance of different options. But as I say, it cannot be by definition in compliance with the SA directive because the SA directive cannot apply to it because there's no plan or programme being prepared. Thank you.
So is that document as a document which has tested various options? Is it deficient in some way because you can't apply the SEA directive to it? Should something have been repeated at the local level or done again to ensure compliance with the SEA directive?
Ultimately, it's perhaps best viewed as an evidence-based document which commissioned along with other evidence by the Co-op Board, which fed into their discussions as to the most appropriate growth level and distribution of housing plus associated infrastructure needs. And just to clarify, obviously the SA report that was generated follows the SA process, in traditionally the way SA is undertaken, essentially generating a set of reasonable options and assessing the performance of those. I was referring to EB 203 for that comment.
So just coming back to the people at the back, because should something have been done differently? I mean, what I think we're hearing here is these options have been tested and evaluated against one another, as you would expect from an SA process. But obviously, you're concerned that it doesn't meet with the regulations. What would have been what needed to be done differently to ensure that it did?
First of all, it's a very high-level assessment, so it would need to be done in more detail at the local level, and it should have been done against alternatives. So it could be seen clearly at the local level what alternatives have been assessed and how they'd come to decide at their preferred spatial strategy. That step in the process is missing. They've assumed that the work done in 203 has confirmed that an SA has been done of the spatial strategy. It hasn't. It's considered the objectively assessed need at the housing market area. It hasn't assessed the spatial strategy of the local plan.
Sorry, so this your concern is over what happens for Epping Forest itself, whether alternative distributions have been tested. Okay.
Yeah,
well, that's
by failing at the first stage, it then ripples all the way through the plan and its process.
Okay, well, we're going to come on to whether or not an adequate SA has been done for Epping Forest's own proportion, but I'm just at the moment dealing with that HMA level figure. So what we're being told is that the option of 51,100 was tested against other options, a higher figure and lower figures ranging from 46,000 up to 57,000. Is there a concern that the process of arriving at that HMA level figure hasn't been appropriately tested, or is your concern the tier below that?
My concern is that the level of assessments, it's very broad brush. It hasn't complied with the significance criteria in the regulations. And it also says two things in the report. One, it's not SEA compliant. And two, it should be used to inform the next version of the plan. So, and as the gentleman from ACOM said, he confirmed that very point. So, however satisfactory or not the results may be, they haven't been used appropriately.
I think, Mum, the broader point is that, as well, is that in relation to your questions of why 511100, was the hybrid tested and how did it perform, those aren't things you can see from the evidence base. You can see at page 29 what the hybrid is, just about, but you can't see what the environmental constraints and relative performances against objectively weighted measures are that led to the distribution which has been undertaken. Now, if you're then doing within your local plan area a spatial plan, and you're taking as given those spatial choices, well, then you have to be able to demonstrate what the alternative spatial distributions of growth, patterns of growth are, and how they've been assessed, which is where your question, as I understood it, was coming from. How did you get to the cap? What was the hybrid? How did it perform? If you can't work those things out, it still starts to look rather like there's just an arbitrary number selected, a mash-up hybrid pushed in to some other options without any actual scoring. I mean, that is, in fairness, what has been done. I think from what I take from what's been said is, well, it's okay. You can do that up there because, you know, it escapes the plan process. And when you get down here, we just sort it all out. I'm not sure that's how the process is meant to work.
Madam Wood. So I was just going to add that obviously the process was designed such that the conclusions from the evidence-based study at the HMA level, of course, feed into the essays for the 4 constituent local plans. And so there are, of course, reasonable alternatives tested for the distribution of development in Epping Forest. So if I might, if you refer to EB 204, pages 7 to 46, you'll see that options the distribution of growth for distributing the quantity of growth at 11,400 new homes as set out in the MOU were set out. Those tested or reflected important spatial variables, including the extent of growth at North Weald Bassett, the level of growth on existing urban green spaces or managed green spaces referred to earlier, and the possibility of higher growth along the central line. That's on page 27 of EB 204. A further set of refined district-wide options were subject to SA in 2017. That's EB 204, page 37, which reflected key distributional issues, for example, more or less growth at Epping Town itself and more or less growth at Thaden Boyce. Appendix 5 of EB 204 also sets out the essay of strategic options for different settlements around the district, i.e. different directions of growth for each of the key settlements. So the accusation that the essay hasn't tested reasonable alternatives for Epping Forest District itself is unfounded.
Yeah, Schedule 1 and 2 of the regulations set out the significance criteria that should be used in the assessment, and they cover short-term, medium, long-term impacts, the permanency of impacts, cumulative effects, mitigation measures, an outline of the selection and rejection of alternatives. All these issues are what make up an SA, and if you haven't done that properly, you haven't got a transparent process to your decision making. You can't just do positive, negative. You've got to back it up by information and evidence.
If I could just jump on the coattails again briefly. I mean, the issue with EB 204 is that it in its own right is not a SA or SEA compliant document. We've set that out at length in detail.
203.
Neither 203 nor 204. And in the hearing statement we've made clear in the appendices, the range of alternatives that are evaluated in the most recent instalment of the SA work doesn't do the job either. So if we switch from reliance from 203 to the most recent iteration, then that still doesn't do the job, because, as has been said, it doesn't score things transparently or effectively, but it also doesn't consider all reasonable alternatives. I wasn't sure if the answer given a few moments ago was that reasonable alternatives have been assessed. The issue is that all reasonable alternatives have to be assessed, and that's in part to enable you to discharge your duty in relation to the question of whether this is the most appropriate strategy. And just the evidence just is not there within the SA report that's been most recently done, or the ones that preceded it, to answer that question. There's whole alternatives options which play no part at all in the analysis, apart from the defective methodology, which we've explained. But for example, you know, we've noted in the hearing statement the issue of a Western Relief Road at Epping. That was under consideration by the County Council. It was put forward in 2015. It was identified as a potentially important option for the local plan, totally untested. The audit trail dies for that in 2015. It's just one of the alternatives which just hasn't been assessed. And there's an issue about coverage in terms of what are the reasonable alternatives and how have they been addressed. And then there's a methodology point. And on both of those grounds, the SA is clearly defective. Clearly.
Just 2 points on the issue of significance. Obviously, of course, we followed the regulations. So on EB 204, page 27, you'll see a discussion of how significant effects were identified as part of the SA process for the local plan. And secondly, on the issue of reasonable alternatives, the case law and precedents from inspectors' reports is that the local authority has discretion as to what it considers a reasonable alternative.
Right. I mean, if I may just address you on that point, Ma'am. I'm happy to focus on the law because that's relevant to your decision. I mean, there is no precedent from inspectors that can shape what a reasonable alternative is legally for the purpose of conducting a SEA-compliant environmental assessment of a plan or programme. The point is that other than kicking out obvious non-starters, which is where the courts have landed, you can kick out the obvious non-starters, the ones that obviously don't achieve the plan objective. And as has been said by Mr. Whittaker earlier, there's a suspicion here of a taint of various things being kicked out that weren't obvious non-starters, things being kicked out because they were undesirable, without any actual environmental criteria, scoring or assessment that sits behind that. So the issue is that all of the reasonable alternatives, no matter how politically unpalatable they might be, have got to be scored and addressed at an equal level of assessment detail in line with a consistent
Sorry,
framework.
so just be very clear. What option do you think has not been considered? In terms of the HMA level, we've heard that they tested more than the OAN. So you're saying that something politically has been what are you concerned hasn't been tested?
The relief road hasn't been considered at all within the SA. Also, ACOM referred to Appendix 5 with the assessments of the settlement options. This only appeared in the 2017 version of the SA. It wasn't in the 2016 version. So it's not clear when that was carried out. It's also not assessed against all the sustainability framework. It's only assessed against certain environmental criteria. It's therefore not a fully compliant assessment of the spatial options. There's no explanation of how they arrived at those options or the reasons for that.
Thank you, Mark. It's 2 points in relation to that. The first point is what we seem to have is an essay, a document in EB 203 at the HMA level that isn't essay compliant, but that's, as far as I can tell, the only document within the essay portfolio that tests different housing figures. So as far as I can see, EB 204 effectively takes the 11,400 as a given and then assesses spatial options around that figure. So as we stand at the moment, we don't appear to have an SEA compliant document which is considering different levels of housing growth. The second point to make on that is I find it hard to marry the two documents. So if we look at the HMA level document, page 31, we've got the various options that are tested. If we have a look at North Weald, for example, within all options, other than option D, where it falls to zero growth, it's the same level of housing, so 1,616. So at the HMA level, we're not assessing the ability for North Weald to accommodate any more housing. Yet when we then drill down into the Epping Forest specific essay, which is at its foundation level, drawing upon the conclusions of the HMA-wide work, we're considering lower and higher growth options at North Weald Bassett. So I'm struggling to see how the two documents marry. You've got a parent global document, if you like, which is assuming a fixed level of growth at North Weald Bassett to get to that figure, and then an Epping Forest level, which is using that figure that's concluded from the HMA work, but then testing different levels at North Weald Bassett. So it would be useful to understand how that works across the two documents.
Thank you. This is a point on your first arrowed question. It's got a slightly different emphasis to what people are talking about. So long as I can make it, it might be better for me to make it later, or I can make it now.
Make it now.
Okay, thank you. The question is posed whether or not the full need has been assessed, and my submission as a simple answer to that question is no. The essay of the spatial option was for 51,100, and to repeat a theme from the previous issue, this misses 600 dwellings, and the full OAN has not been assessed. If you look at the 2017 essay EB 204, and if paragraphs 7.4 to 7.6, it's acknowledged that the HMA OAN figure is 51,710. Then 7.6 states in terms it was not considered necessary to revisit alternatives for the level and distribution of growth for the HMA set out in the signed MOU. It's quite straightforwardly not assessing the full need figure as came out of the 2017 SHMA. Now, it might be that the answer to that which is offered is that a higher figure was assessed, the 57,400 figure, which we had mentioned earlier. But in my submission, that's no good for two reasons. Firstly, the OAN figure has special significance in policy by virtue of it being the objectively assessed need figure. But more fundamentally, and secondly, if you assess a much higher figure, for housing, then it may well be rejected due to sustainability concerns, which wouldn't arise for a lower figure, which would be closer to the OAN. So just saying we assessed below the OAN, and we considered a much higher, and we considered a higher figure just because it's within the range. In my submission, that is not enough to prevent the answer to your first question there being no.
Thank you. There's a number of concerns that obviously arise out of the evidence that's been put to you. Firstly, that the assessment done EB 203 is reliant upon sites put forward by the local planning authorities in terms of the assessment. Secondly, that 51,100 was not actually assessed. If you look at table 4.1, there is not an assessment for that figure. The starting point where that figure was assessed, it was described as being positive because it was over the OAN, so therefore it had additional benefits in terms of one can imagine those being social and economic benefits in terms of increasing access to housing, etc. That is no longer the case. So that assessment has to be revisited, I would suggest. And looking at table 4.1, it's a point that's been made by Mr. Richards across the table from me. When you actually look at the options that are set out, besides the different quantum around Harlow, there really is about 2 options there. And when you actually narrow that down to the 2 options, which, because most of those options are about providing for a much lower figure, 46,000, there's only 2 of those options in that assessment that are close to or above the 51,000, and that's the 2 on the far right. And when one looks at the difference there really isn't a lot of alternatives being looked at. And therefore, I don't think the idea of is there potential to provide for this need somewhere other than just putting more and more into Harlow? Is that the only game in the book? I would suggest not, because one's got to look at meeting demand, not just need. You've got to look at where that arises. You've got to look at whether or not there are other sustainable locations in Epping. You know, there might be another place for the train station and a supermarket, for example, which could facilitate further development. So I really don't think that that's, you know, that has gone far enough in terms of looking at alternative options. I'll leave it there because I've got points to make about whether reasonable alternatives have been looked at when we get down to the Epping level, but that's your second bullet point. So I think you want to draw a line there, don't you?
Yes, please. Explain that relationship.
Yes, so put simply, the EB 203 documents an extensive process of optioneering undertaken by the Co-op Board for Sustainable Development, which involved developing a series of options for growth and distribution of housing across the HMA, which were tested through a sustainability appraisal process, albeit not one that complies strictly with legislation, because it cannot by definition. Also tested through transport modelling, the habitat regulations assessment type work. The Co-op Board then settled on a preferred option, which totaled 51,100 homes, distributed as follows: East Hertfordshire 18,000, Epping Forest 11,400, Harlow 9,200, Uttlesford 12,500, of which 16,100 of those 51,100 homes would go in and around Harlow for reasons set out in EB 203.
Can you just pause there? Just pause there on something. So I just want to ask you about the 11,400 figure specifically. So you say there was this extensive process of option considering through an SA process, albeit potentially not legally compliant because you can't apply the legislation to it. But it also looked at transport and HRA, and then you've said, and then the board decided upon this preferred distribution, presumably as a result of looking at the SA outcomes, transport and HRA. Can you say a little bit more, because this is a question I was going to ask under my third bullet, but can you say a little bit more about precisely how Epping Forest's own apportionment of 11,400 was arrived at. Why is that specific figure arrived at for Epping Forest?
Sorry, apologies.
It's very important for the webcast.
Well, I refer you to EB 203 on page 4 onwards. That table sets out the 6 options that were considered. If we scroll down the table, you will come to the part of the table that addresses Epping Forest district. In that, you will see it sets out housing figures at the time, because this is written back in 2016, for completions, permissions, assumed windfall. It then sets out alternative figures for different strategic sites around the Harlow Fringe, at Latham Priory, West Sumners, West Catherines, east of Harlow in particular. It then sets out alternative figures for some of the towns within Epping Forest. Now, of course, at this point in time, this is back in 2016, these numbers, of course, have changed, and of course we weren't trying to limit the autonomy of the Epping Forest local plan or any of the constituent local plans in the HMA. The whole point of this was to set the framework for each of those 4 local plans by providing a growth figure which they could then work to. And you'll see it says Epping Forest, this is on page 7, the Epping Forest total there under option A, for example, is 11,093 homes, with the OAHN being 11,300, and you'll see different figures across there. But the OAHN for Epping Forest at that time was 11,300. And as I say, the chronology is very important here. These options were developed to meet the OAHN as defined in the SHMA as it was then, which was 46,100. However, all the bottom-up work indicated that a total figure of 51,100 homes could be reasonably accommodated within the HMA, taking account of all the evidence. And that figure anticipated the new OAHN figure of 51,710, which was then presented in 2017. I hope that's clearer.
So I stopped you halfway through to ask you how that 11,400 figure was. You were going on to explain how the EB 203 document then fed into the SA work done in EB 204 for the council specifically.
So the Co-op Board, having resolved on a preferred option, which is set out in the report, we then, obviously for the Epping Forest local plan sustainability appraisal, took forward the figure in the MOU, which is, of course is a reasonable step for the council to take. They had agreed to provide 11,300 to their partners within the HMA. We then tested distribution options for that said figure within Epping Forest as part of the local plan SA. So that figure links the 2 documents together.
So is it the case then that that figure was taken from the agreed preferred option? Has a higher figure for Epping Forest specifically ever been tested to see whether it could be pushed beyond that to meet the OAN?
Well, just bear with me one moment. So yes, if you go back to EB 203, and this is page 7, you'll see that we did test a figure for Epping Forest which up to 14,152 new homes over the planned period.
Up to what, sorry?
Over the planned period, up to 2033.
Figure.
Oh, I'm sorry.
14,150.
Yes, 14,152.
And what did that figure represent? Why 14,152?
If I refer you back to the table, so on page 6, you'll see how that figure was built up. It includes, well, you'll see their figures in the Epping Forest part of the Harlow Fringe, 2250 at Latin Priory, 1200 at West Sumners, 1100 at West Catherines, east of Harlow 750, West Pinnacles 1000, and Lander Riddings Lane 50 in particular. And it then also takes the higher numbers for each of the settlements in Epping that have been looked at previously.
Mr. Richards.
Thank you. I think in terms of option F, yes, it tests a higher figure of 14,152, but I think it's going back to Mr. Bolton's point that the only difference, I mean, if you compare it to the preferred strategy, the only difference is housing growth described as Epping Forest District part of the Harlow Fringe. So if you look at every single settlement, there is no difference between the far left column and the far right column. It doesn't matter if you're looking at Epping at 513, Waltham at 406, they're all identical. So what the essay process is effectively saying is that there's a fixed, finite level of growth in every single settlement other than around Harlow. And I think the problem that the council have got themselves into is if during matter 3 it is concluded that there is potentially a higher housing level requirement, the only document that is SA directive compliant, all it looks at is one fixed figure of 11,400. So it only takes a slight adjustment to that figure and there isn't an SA for this plan. It's not in the case of, and I'll use Guildford as an example of one I've been involved in recently, where their SA tests different growth options. So as their OAN went slightly higher, that was fine because the SA had looked at that and they already had conclusions about the environmental impacts. At an Epping Forest level, they don't have that. All they have is one fixed assessed figure of 11,400 and then some spatial options within that. There's no give in that figure. So there's no ability to go higher and then have a look at this SA, which I think, depending on how the Matter 3 session goes, is going to cause significant issues regarding the plan.
Sorry, is that okay? Right, okay, thank you. What we just heard is that the EB203 sets the framework for growth. So this is a document which is being used for a spatial planning purpose, and there are spatial planning choices being made at that level which have not been informed by proper environmental assessment. And that's the bottom line here, and that's been made clear in the hearing statement, and it's been repeated by others around the table, but nothing that's been put forward has undermined that point. These choices have been made, and they've been made without the kind of matrix of scores which enables you to understand, oh, well, why did they select that option? Why was that the best one? What were the relative merits of that position? From a transparency, participation, environmental decision-making process that SEA is there to ensure takes place, that is absolutely missing, critical. It's a legal point for ultimate plan adoption, but it's still an issue. But the fundamental issue for examination here, and particularly given, as I said earlier on, how important this examination is, even based on the council's position, because nothing in the Regulation 19 stage has been consultative, that whether or not the alternatives are fully, fairly and properly assessed and laid out within the confines of the IP evidence base is an absolutely critical issue. And they're not. Both from the high-level spatial choice, why have you selected the maximum AN capped figure, but also as we then drill down to, well, how have you tested the Epping Forest figure? What were the permutations of that? How has that been assessed in a transparent matrix of environmental performance of the relevant options? We can't even see what all the relevant options are. So, we've said earlier it's entirely defective, and there's nothing that's been said today that suggests it isn't.
Can I ask one sort of last question, and we might move on to the site allocation issue. But on that point, so I think what you're saying from the council side is that within the 11,400, you tested different distributions of development. How about the point that Mr. Richards makes? Was any other growth option that didn't rely upon Harlow tested? So was it tested to see whether you could find more in Epping Forest's own settlements in order to raise that number without relying on increasing development in Harlow?
As I say, the HMA level work set the framework in the sense of providing a number, 11,400, as a basis for considering distribution options within Epping Forest, and that figure represented the OHN as it was then understood. So I don't see anything particularly unreasonable in that. And of course, the HMA level work was primarily focused on the question of how much development should go in and around Harlow, which is the key strategic matter for the HMA authorities to grapple with. And so the conclusion of an enormous amount of evidence gathering was that there were a series of strategic sites within the Epping Forest part of Harlow Fringe which should be reflected in the Epping Forest local plan.
Okay. Thank you. That's been helpful to me. Unless there's anything else that anyone wants to say about the quantity and distribution of development, I think I've probably got enough on that. So one last point from Mr. Bolton then, but then we'll move on to the site allocations, or on the site allocations. Mr. Bolton.
Thank you. In terms of EB 203, page 34, the ORS, the demographic consultants, advised that at the time of the exercise being undertaken by ARAPS, the objectively assessed need was considered to be 54,608. And my understanding is, well, not my understanding, that figure was not tested. So the most recent advice on what the objectively assessed need was not tested as part of EB 203. What was given is the 51,100. That, I assume, is a figure that was given to ARAPS. It's not derived from their analysis of what's most sustainable. Reading through it, that seems to be the evidence. So we've got a figure that was given at 51,100, which is not a result of the analysis. It's a figure that's been transported into the analysis, and ARAPS have come to the conclusion that it's quite good. It's obviously not good enough in terms of meeting what was the identified need at the time. So there's a question there about that. You know, why wasn't the full amount tested, full OAN tested? Where did the figure come from 51,100? And lastly, the point comes back to the point Mr. Richards was making, is when one looks at alternatives outside Harlow, there was no real assessment of the capacity of the other areas undertaken at the EB 203 level. That must be correct. It must be the only conclusion you can take from the evidence before you.
Have you raised your boards to comment on the distribution or the site allocations?
It's specifically distribution, ma'am.
Okay, well, had said that would be the last one, so we'll do those, but no more wards on that now.
Thank you, ma'am. I'm going to start off and then Councillor Pond will make some further specific points. And as you would expect, our points are Loughton specific, but just to set the broader context, this is from just our brief analysis of the essay. And it's fair to say we have found the essay a little bit of a paper chase, so apologies if we've missed anything due to that. So what we're seeing is, from our perspective, we can't see that alternative strategies for spatial distribution have been tested. Our view is the preferred strategy seems to have been decided upon prior to testing reasonable alternatives. And within that context, only local level alternatives for individual settlements have been tested. Now, turning specifically to Loughton, we can't understand on what grounds the numbers have been allocated to Loughton and tested. All of the options for Loughton do propose high housing numbers of between 900 and 1,100, despite the lack of sites. So from our perspective, a reasonable alternative would have been to have a different district-wide distribution. The essay does admit that Loughton's constrained and has limited capacity for development. So obviously we'll be returning to site specifics, but it looks as if Jessel Green has been included based on the size of the town rather than its merits as a development site, and based on a sort of broader aspiration for Loughton to be a major town. So we haven't seen that number for Loughton being reassessed in any way, and in turn that has broader implications for the impact on the SAC. And our view is that a reasonable alternative would have been to restrict development in the vicinity of the SAC.
Ma'am, I'd also draw your attention to para 226 of EB 131, in which it is stated, this is a very early document, that growth of Loughton and Debden is wholly restricted by the SAC, Epping Forest, the River Roding, and the local meadows and greenbelt gaps. So it was early on in this process acknowledged by the District Council that it should be looked at least, that a different model of spatial distribution should be examined. And one of those, broadly, with the exception of Waltham Abbey, was what was called in that document distribution away from the central line. Now, this has undergone a complete metamorphosis because in the Matter 1 statement at paragraph 66, the local planning authority states as follows: with respect to recreational pressure and urbanisation avoidance, the avoidance of harm could, and this is their words, in theory, be achieved by placing all new development more than 6 kilometres from the SAC. However, they say, this would result in an illogical and unsustainable pattern of future housing development. Now, in my view, that is an ex cathedra statement, unsupported by evidence, and it includes the words in theory, but in fact, development could, in practice, be achieved by developing in the northeastern quarter of the district, for which no allocations are planned. Sustainability for that area should well derive also from Chelmsford Borough Council's aspirations for a western bypass and for development to the west of that city. And that has, I think, been wholly ignored by the local planning authority, although it was raised on a number of occasions in the member workshops. The other point I think that follows from that is that papers EB 203 and EB 204 were formulated and worked upon before the 3 European Court judgments, which I know, ma'am, you have put off till the 21st of May. I don't want to trespass on that territory, but at least that, I think, should have been a red flag to the local planning authority when the judgments of People Over Wind and Holler and others were in, after the period anyone could comment on the draft local plan. So for those reasons, we believe that all options and indeed all numbers for the district have not been formally and fully evaluated, especially in relation to housing numbers and the harm to the SAC.
Thank you. Did the council want to come back on that before we move on to the sites, any of the last points that have been made?
If I might, I just want to reiterate that alternative options for the distribution of growth were tested through the SA process. That's set out on pages 7 to 46 of EB 204. In particular, on page 27, you will see that a reasonable alternative looking at lower growth urban green spaces, and that refers to Loughton Buckhurst Hill, was tested through the SA process. Thank you.
Thank you. So we'll move on now to the role of the SA in deciding between potential site allocations. Again, I'll just read out my couple of questions and then I'll start with the council and go around the table. So we will return, obviously, to this matter in more detail under matter 5 concerning site selection. But it's been put to me that the plan's site allocations are not, in some cases, informed by the findings of the SA process. So my first question, general question, is given the timing of the publication of the site selection report, did the SA supporting the Regulation 19 version of the plan take account of the information contained within it? And secondly, perhaps as a perhaps to use an example that's been raised this morning about East Epping, as it was found by the SA of the draft plan to be a more suitable strategic option, and yet with no apparent changes in circumstances, it was removed from the Regulation 19 version of the plan. So perhaps if you could explain what factors other than the SA, if they were involved in decisions of this type, and what weight the SA was given alongside them.
Just to be clear from the very outset, so the site appraisal process undertaken by the council was designed to reflect the sustainability appraisal objectives, therefore integrating the sustainability appraisal process from the outset. And the explanation for that is set out in EB 204, page 23, and also if I refer you to Appendix 4 of EB 204, you'll see there the site selection method criteria and how those relate to the sustainability appraisal objectives.
Do you just want to comment first of all on the specific question I raised about whether whether the site selection report and the site appraisals were sufficiently advanced that they were taken into account in the SA process? Or...
Well, simple answer is yes.
Right. Okay. We might come back to that one. Okay, Mr. Hollingworth.
Thank you, Marmon, and thank you from the council there for the confirmation that the site selection report does indeed form part of the SEA. That was one of the queries we had. We weren't quite sure whether it was seeking to perform that function. Obviously, SEA is required to explain the reasons for the selection of preferred options, rejection of others, and I think the only document that does do that is the site selection report at the allocation, the site-specific level, rather, for the purposes of allocation. It's certainly not within the main body of the environmental report itself. But whilst I appreciate we've discussed at length this morning about consultation on Appendix B of the site selection report, and that was obviously within the context of the legal requirements in respect to the SCI. entirely separate and distinct to that is the requirement under the SEA regulations, Regulation 13 specifically, for interested parties, or those who may be affected by plans, policies, etc., to be consulted on the environmental report, and by extension that must then include the site selection report for this. So that does give rise to a number of concerns in respect of the process, in respect of the SA for this plan. We've set out in our hearing statement, Ma'am, how we think this and a number of other defects which have been identified can be remedied. That doesn't require withdrawal of the local plan. We do feel that it's a more pragmatic approach which does ensure requirement with the SEA regulations without having to revert to a much earlier stage. And while we are mindful of the findings of the initial 2010 scoping report, I think for SA, I think that's EB 200, in which it does identify significant negative impacts from there being no plan for Epping Forest. So I think it's particularly important in this instance that we do seek to cure the defects rather than to simply find the plan to have failed the test of soundness and or legal compliance. Thank you.
Thank you. The guidance set out by government in the 2015 on SEAs state that the sustainability appraisal is a systematic process that must be carried out during the preparation of a local plan. Its role is to promote the sustainable development by assessing the extent to which an emerging plan, when judged against reasonable alternatives, will help achieve relevant environmental, economic and social objectives. So that's what it's meant to do. What has happened and has not been challenged is that the initial EB 203 was undertaken on the basis of the sites which were given to ARUPS in terms of what might happen outside of the Harlow fringe. What we've evidenced clearly in paragraph 1.31 of our submission is that a site identified as sites 1C and 2D on page 130 of EB 1002 were identified by the Allies and Morrison's master plan study for North Weald Bassett as being the appropriate way forward to develop that area. Now, that goes a little bit beyond just saying these are reasonable alternatives. It's saying it was the appropriate way forward. At no time have those sites been assessed to be an unreasonable alternative or indeed unsustainable. What we see in terms of the 2016 report and the Regulation 18 consultation is the correct site was not addressed. The meeting notes and the correspondence relating to that meeting identified that when ARUPS met my clients, they presented my clients with a site which could accommodate up to, I think, 5,000 dwellings. It's a massive site, and they had ruled that out and assessed that site. What they had not done is assessed the site which had clearly been identified as a suitable extension to North Weald Bassett in the council's own documentation. So they just didn't do it. When challenged on that, the council responded that my clients had misunderstood, if like, the purpose of the meeting, and the meeting wasn't there to assess their site, but to allow the council explain why this larger site that had been assessed was not allocated. But this larger site is something my clients had never put forward in the plan. It wasn't put forward by the council in their earlier master plan. So to a certain extent, why on earth was it being assessed? The reasonable alternative, which is a much smaller site for up to 275, 300 dwellings at North Weald Bassett, simply hadn't been assessed. In terms of the 2018 approach, it is simply disregarded at the first stage as being a less suitable strategic option. Those are the words that are being used. Now, I don't think they're Arup's words, to be fair to Arup. I don't think Arup have gone through and sieved out a lot of sites on them being less suitable strategic options. I think they were just told to exclude them from the assessment. And when one chases that through, one can only find the basis for that might be an exercise in 2014, where there was an exhibition and 20 out of 35 respondents claimed they preferred development only to the north of the village, while 8 preferred to the south. And further on, there seemed to be a working party of officers and members at some point where this decision was made. Now, this is clearly a sustainable alternative. It's not been assessed. It's been rejected as a less suitable strategic option. And that's not the first time we've heard this around this table. We've had a number of people around this table who are saying their sites have been excluded from assessment because of that statement. And what would be helpful, I think, at this stage is to understand, was that an assessment made by Arup's, and if so, what's the explanation to it? Or if it wasn't, where was that decision made, and what are the reasons for it? Because it seems to me it's simply, it's hidden away, so it's quite difficult to find. It seems to me that there's a number of options that are actually probably better options, but politically unacceptable, and have therefore been moved out of Arup's assessment with those words. And that suggests a systematic failure of the process, not just my side or my client's side, but indeed a few other people's sides as well. So an explanation of what those words mean, where that decision was made, and the justification for that decision on each of the sites that it's been applied to, and it's more than one.
Okay.
Would be very helpful.
Okay, thank you, Mr. Bolton. I'll ask the council to come back on that. Mr. Ricks.
Yes, thank you, Madam. Yes, I find difficulty with the sustainability appraisal, both in terms of how the housing distribution between settlements has been derived, and that's been covered in the session just now. But insofar as our site is concerned, the sustainability appraisal included a wide area called West Expansion of Chigwell, but didn't look at smaller options within that broad area for rounding off purposes in the green belt. And part of my concern over that is, again, the inaccuracies against the site at Hill House in terms of the inaccuracies of how the site is described in various ways. Now, I appreciate all that can be looked at and examined in matter 4, I think it is. But again, I would like to flag up these discrepancies in the evidence base that may have fed into the sustainability appraisal, that may have fed then into the site selection process insofar as Chigwell is concerned. And that does cause me great concern in that regard. Thank you, Madam.
Yes, thank you, Mark. Yeah, the problem I think I have with the essay is at what point the options which were looked at the draft plan stage should have been assessed and then fed into the submission draft plan. So clearly at Epping, the whole strategy for the town changed between those two plans. And the essay did not assess the option which actually went into the submission plan, because that option was never on the table until the submission plan was actually published, because at the draft plan stage there were a number of options which were discussed and discounted, and they were assessed within the Epping part of the plan, but none of those options were the option which was then chosen, which was to put all the development in one site. So I don't see how this essay could have really come to the conclusion that that was the most sustainable option when that option was never on the table until the final plan was published. To everybody's surprise, all of the sites were taken out in Epping apart from the one.
Okay, well, sorry about that, everyone. I've been suffering from the lurgy that I think lots of people have, but managed to stave it off until almost 5 o'clock, so apologies for that. I recognise there are still some boards around the table, but before I lose the thread of what's been said so far, I just wanted to ask the council to clarify a couple of things, and then we'll move on from the back. So the first one was just to clarify that is it the position that the site selection report sort of performs the SA function sitting outside of the SA document itself? Perhaps if you could just clarify that for me, and is that a usual way of doing things, a legitimate way of doing things?
Yes, so just to clarify, the SA looked at reasonable alternatives at 3 levels, district-wide, which I've already discussed, at the level of different settlements, i.e. different directions of outward growth from settlements such as Epping, and then, yes, as you say, the SA process is embodied within the site selection process, as we felt this was a pragmatic approach which wouldn't duplicate effort, would make the process easier for stakeholders to navigate. That is not an unusual approach. We've done that recently for Sevenoaks District Council, for example. I would just point out there's absolutely nothing in legislation, the SA directive or the implementing regulations, or indeed in the planning practice guidance as to how one goes about assessing reasonable alternatives and indeed what those are. There's certainly no mention of site appraisal at all in the PPG. So councils are free to adopt a sensible, pragmatic approach. Thank you.
Perhaps I can just add that we undertook the same approach both for the draft local plan and the submission version local plan, so it was a process that was followed through. And taking the point about whether ARUP were directed, they absolutely weren't directed. We looked at preferred directions of growth across the district for all the settlements and taking into account all the evidence, both from the technical studies that have been done, but also the comments we received from stakeholders and other residents and groups.
And the second point that Mr. Bolton and I think Mr. Ricks have made, and I know that this is going to come up in other areas, particularly I've raised some issues about it in relation to the Greenbelt session. It seems that it's being suggested that the council has looked at sort of wide areas but not necessarily done a detailed enough analysis of the smaller sites in some cases. Could you just comment on that and perhaps just clarify for me the point that Mr. Bolton is making?
The site selection process was very detailed, and no doubt we'll come back to that the week after next, when we discuss that in greater detail. But it looked at about 32 different criteria for each and every site and assessed them. And as I said earlier, there were over 800 sites that were in the mix. So there was a very detailed assessment of each and every site, and that took account of all the technical evidence and other work that had been done, including the Greenbelt Review, and that was done at more fine grain level then for each site.
But is Mr. Bolton's concern that his client's site was ruled out because a sort of wider site was assessed rather than a smaller component which might have had different implications?
His site was reassessed for the local plan submission version, and that assessment set out in the site selection report. The area where this site is situated is in a less preferred strategic option for growth. That is the same in the 2016 draft local plan and was carried forward into this one. We'll come back to it, but the North Wales Bassett Master Plan actually looked at 2 different options for growth, and the preferred option was the option not with that site contained in it.
And then finally, before we take the last points around the table, to come on to the point that was raised by, I think it was Mr. Belton earlier, who spoke about the change between the Epping direction, and also Mr. Friend has raised it. And it was one of the questions I read out at the beginning. Perhaps if you could just explain, using that East Epping example, it was found by the SA of the draft plan to be a more suitable strategic option. What changed between then and the Regulation 19 plan? What factors with the SA, together with the SA, led to that decision?
Sorry, Madam, I'm just finding the reference. So within the site selection report 2018, which is EB 805, there is an explanation as to why changes have been made at a settlement level to particular site allocations. It doesn't mention specific allocations, but it talks about any changes to the pattern of growth at the settlement level. That's at paragraph 2.137 on page 46. And that includes an explanation of changes made to the plan at Epping.
And in response to the specific point that Mr. Friend raised, if the South Epping option hadn't been on the table before, how was that? How did the SA process inform the decision to allocate that land?
If I could just refer you, Madam, to EB 204 and page 37 onwards. You'll see there are various spatial options which include different sites around Epping that were tested as part of the SA process over and above the site selection process. So that may be of help.
If we just take Mr. Belton now, then I'll come to this. Okay.
Thank you. I wanted to expand a little bit on what Mr. Friend said and then just respond to the points that the Council have just raised. So as I mentioned earlier, my client's land to the east of Epping was included in the Regulation 18 plan. And in the Regulation 18 plan on page 124, 3 other options for the spatial strategy of Epping were discussed, and they effectively included the expansion of the settlement to the southwest, the expansion of the settlement to the north, and the expansion of the settlement to the northeast. So none of those alternatives that were raised and assessed at the Regulation 18 stage involved removing East Epping and creating a larger extension to the south of Epping. On that basis, one would expect the sustainability appraisal of 2017 to therefore start with that baseline of the preferred strategy at the Regulation 18 plan, and then start to assess whether the change of removing Epping East and making Epping South larger is more or less sustainable. Unfortunately, the 2017 SA does not do that. Reference was just made to the 3 plans in the SA, so pages 38, 39 and 40, which very helpfully do include a colour-coded key which looks at constant elements in the assessment of alternatives, and in red there is the variable options. Now these plans unfortunately don't help, they don't answer the question, because in each and every one of the plans the constant is Epping South as it's in large form as it now appears in the Regulation 18. None of the options consider Epping South as it was at the Regulation 18 plan, including then a direction of growth to the east of Epping. So there's been a jump, if you like, between the council's preferred strategy at the Regulation 18 and that which they're now promoting, and the sustainability appraisal provides no assessment of options. So in my opinion, to comply with the regulations, this sustainability appraisal needs to be updated. It needs to go back and it needs to assess as a starting position the Regulation 18 strategy, not jump to what the Regulation 19 strategy is. It then needs to assess whether the direction of growth that the council wants to go in, i.e. the Regulation 19, is the most sustainable and most appropriate option. And if it is, great, we can proceed. If it's not, then obviously there's a fundamental problem with the plan. Now, I'm not in a position to prejudge what that assessment of reasonable alternatives would be. But as I said this morning, if you actually go to Appendix V on page 127 of the sustainability appraisal, I think it's quite telling on the council's own assessment of Epping East. I mentioned this morning that it concludes that Epping East is the least harmful of the sites on the edge of Epping in terms of greenbelt. What I didn't say this morning is that the council's own assessment goes on to say that Epping East would also be less harmful to the Epping Forest SPA. The Epping East would also maximise opportunities to focus development sustainably to the southern part of the site, which is in very close proximity to transport services, i.e. the underground. And the concluding paragraph on page 127 reads that overall, while it is noted that the strategic option is sensitive in landscape and heritage terms, given there is potential for this harm to be mitigated through design, and as the strategic option is less harmful in greenbelt terms and located sustainably on the eastern side of Epping, when compared with all other strategic options at the settlement level, it is judged to be a more suitable strategic option. So if that's the conclusion the council are reaching in its own essay, there surely has to be an assessment of that option. And I personally think the conclusion of that assessment of option would be that the Regulation 18 spatial strategy is indeed more appropriate than that which is included in the Regulation 19 plan before us today. One final point, it's helpful to understand that the site selection report does in fact form part of the essay process. That does raise another significant question in my mind, is why is Appendix B of that report concluding that Epping East has a far greater impact on the greenbelt than other alternatives around Epping, when Appendix V of the sustainability appraisal, all part of the same document, concludes the complete opposite. Obviously, Appendix V is right because the two greenbelt studies that the council have done very clearly conclude that Epping East has a far lesser impact on the greenbelt. So there's again another tension. If this is supposed to be seen as one holistic document, then it's reaching very different conclusions.
Thank you, Mal. I think it's just really building upon the point about the relationship between the essay and the site selection report, and really just the difficulty of following and responding to the essay as part of the Reg 19 consultation in the absence of Appendix B. I won't go over old ground, but just in terms of taking Roydon as an example, if you look at page 143 of the essay, you effectively have a verbatim repetition of the site selection report in terms of why the western expansion is less preferable than the eastern expansion. But obviously that's taken from the site selection work. It isn't work that's been done by AECOM specifically. So it's impossible really, and it's not a deficiency necessarily of AECOM. It's the fact that they've obviously been provided with a form of the site selection report which the council considered was sufficiently finalised to inform an essay, dated December, yet 3 months later they decide that the site selection report is sufficiently finalised to share with the public. Surely it's imperative upon the council that they should have had the same level of confidence when they allowed AECOM to have sight of it, that it was in a form that the public could also have sight of. Otherwise, you have to raise inevitable concerns about how robust that version of the site selection report provided to AECOM was, because none of us know what that version of the report was. And that's, I think, for us, that's a fundamental point. It's similar to the Epping point in that the western side of Roydon is strategic option that's less harmful to the green belt. So it's absolutely fundamental to understand that site selection report work.
Ma'am, I'll be brief, and I hope I'm not going over old ground, but it is a specific point regarding Jessel Green and the gentleman from ACOM's response regarding urban green space and lower growth at them. A proper consideration of that could have resulted in the removal of Jessel Green. However, this was only assessed in the context of the decision regarding the overall numbers for Loughton, is our understanding. And the conclusion written in the SA is that the option would result in a need to divert growth to locations on the edge of Loughton in order to avoid unreasonably low growth at the town that are sensitive in terms of flood risk and biodiversity. There was no opportunity to reassess the numbers for Loughton, and in our view, that's then led to the allocation of a site that's perhaps not suitable.
Yes, it's just with regard to the site selection report, which the council now says part of the SA. There's a slight discrepancy in the site selection report, which is EB 805 AK, section 4, page A19, paragraph 4.46. And it says the SA assessment undertaken by ACOM will establish the impact of the candidate preferred sites alone and in combination. Well, that to me, I understood that to mean it would be, the site assessment would be done within the main body of the SA rather than the site selection report. Can the council explain?
Thank you, Mom. Just conscious that this is focused on legal compliance of sustainability appraisal and SEASA, etc. And of course, matters of judgment following the SA aren't matters of legal compliance. They're matters of soundness, and I think a number of issues being raised are into the soundness territory. But I think one of the points, or one of the questions raised earlier, was whether defects in terms of how sites had been assessed as part of the site selection report, which of course we now understand is part of the SA, whether that's a legal compliance issue. And what I would say in relation to that, Martin, is that whilst the site selection report has provided very robust reasons, as it's required to do, as to why sites have been selected, so it's fulfilled that requirement of the SCA regulations. What it has failed to do, in our view, is to adequately explain why other sites have been rejected. And of course, that is the key element. And part of the reason for that appears to be errors within the site selection report. And as we've heard around the table, a number of issues there. I'd also add to that, Marm, and whilst it's something we can discuss other matters within the examinations, some of the reasons given for the rejections of sites are somewhat spurious, in all honesty, such as the site's too small to deliver X number of dwellings, etc. So,
sorry, so just in relation to the points you just made about soundness and judgment, is your point that it doesn't explain? Is it an absence of explanation, or is it that you don't feel that they're robust?
Sorry, it's the explanation for the reason for rejections is based on erroneous assessment of sites such that it can't be considered legally compliant because it doesn't demonstrate a reason for rejection. And I think what neatly exemplifies that, Martin, if I can draw your attention to EB 410A, which is the Housing Implementation Strategy 2019. Now, within that document, the council seek to explain why they are unable to deliver enough homes to meet local need within the early years of the plan period. At paragraph 412 of that document, Marm, the council explained that one of the options that could have been pursued was to look at allocating additional smaller sites, But the reason given why they couldn't do that was that this would require a significant further evidence work to be undertaken. Now, if reasonable alternatives had been considered to the same level of detail as selected alternatives, then clearly they would have had the option to go back and look at those as well, without having to do this additional evidence.
Mr. Bolton, then we're going. I'll come back to the council, then we're going to move on.
Thank you. Just to give you the site reference in the site selection document, which refers to our site, it's SR 0269A-N. And when you look at what's happened to that site, we've already acknowledged, I think, that the site being promoted is much, much smaller than the site that was assessed. But when you look at that, you've been told the site was assessed. It was insofar as it passes, if you like, the first sieve test, but fails because it is located within, supposedly, an area which is a less preferred strategic location for growth. We've not had a definition of what that means or why that is. But certainly, when one looks at the site my clients were promoting, it doesn't share the same characteristics of the larger area. It's a simple thing as that.
Mr. Bolton,
So,
we'll come back to that maybe at the site selection. I understand the point you're making.
Okay,
We need to make it again.
The second point, though, is that this should not be a paper chase. And I think everyone sitting around this table is finding a great deal of difficulty in working out why their site, in some cases, why sites have been allocated, in other cases, why they haven't been allocated. It is a complete paper chase in terms of the SA. And while that might not, well, I think there is clear guidance that should not be the case. You know, and, you know, the status of this appendix, which wasn't there at the time of consultation, I think is, you know, it makes the whole thing
Thank you.
very difficult.
Thank you. Can I just ask the council a couple of just specific questions before we finish? Perhaps if you could first just comment on the point that Mr. Hollingworth made about the degree of the level of detail of explanation about why sites were rejected. If you could just comment on that first of all.
I think, as we've said before, there were a large number of sites. We've tried to include as much detail as was proportionate to meet the requirements and to give an explanation of why sites fell out at particular stages in the site selection process. And you know, what we've taken a proportionate approach to that. You know, the site selection report is already many pages long and very detailed.
Thank you. I think, but is there anything else that the council particularly wants to come back on? Thank you. Thank you for that. We'll leave that there. Now, depending on people's answer to question 6, I don't feel the need for another break at the moment. But my issue 6 was: is the plan legally compliant in terms of how it seeks to address climate change? Now, I've read the council statement and others to the extent they address it, and I've got no further questions. Does anyone want to raise anything in relation to climate change? No? Okay, thank you. So we'll move on to issue 7. So this is perhaps a more procedural point. Is the plan legally compliant in respect of superseded policies, mapping and monitoring? Now, I asked the council a question about how it had identified its superseded policies, and from its statement, I've got no particular problem with the accuracy of your Appendix 2, and if you prefer to leave it as it is, I don't think there's any soundness-related issue there. So people will alert me if you have anything to say on any of these. The submission policies map, the council's explained that this consists of just the A0 map, which is EB 114B, and not the maps within the plan itself or those in Appendix 6. Is that correct? Thank you. Okay. So my question there is simply then, has the council ensured consistency between the policies map and the maps within the plan in Appendix 6? For example, in respect of site boundaries?
As far as we're aware, we believe so.
So just if any map changes are required as a result of the examination, then you just need to obviously be careful that they're amended in all the relevant places.
Yeah, absolutely.
Okay, thank you. And then the next point was consistency between the maps and the legends, including potential modification to include a full legend within the plan itself. So in response to my question about this, the council proposes to add a full legend to the plan after page 44, and that maps 2.2, 2.3 and 2.4 will refer to that larger legend. Now, I agree that it would be clearer to include a full legend after page 44. This would be an MM, main modification. Should the full legend then replace the mini versions on these three maps? Yep.
Yes, we think there should be one.
Okay, and then how about in chapter 5 of the plan? Would it be, which is the places policies, I believe?
Yes, I think we should be consistent throughout.
So in chapter 5 at the moment, each of the maps has its own mini legend. Would it be clearer to just put probably put another one in at the beginning and then delete all of those?
Yes.
Mini
Yes,
legends?
I think it would.
Okay. Anyone disagree? No, not with that. Okay. Okay. Okay, and then the next question was about the... Sorry, Mr. Pond, did you want to raise something?
Just to say that a number of us in using Appendix B, the notorious delayed document, we found the legends extremely difficult to interpret. So this is to ask you whether you could request the council to look again at the labelling of those legends and colour code keys to see whether they could be improved.
This is in the site selection report, or... Okay.
That's a completed piece of work. We don't intend to revisit that at this stage.
Just moving on down the agenda, whether a key diagram is needed was an issue that was raised. Now, the council's position is that it's not necessary to include a key diagram to indicate broad locations for strategic development. And that's because in the context of paragraph 47 of the MPPF, the plan does not identify any broad locations for growth. And the council's position is the strategic development is shown on the submission policies map. Now, that explanation seems reasonable to me. And I'm not sure what the purpose of adding a purely illustrative key diagram would serve. So I'm content with that, but I just wanted to check whether anybody else disagrees with that. No? And finally, on monitoring, I don't have any further questions concerning monitoring. Does anybody else want to raise anything about monitoring? No. Thank you. So that's the end of the agenda. Thank you very much. I just want to make sure, without wanting to open up the floor again, to make sure that there aren't any burning points that haven't been covered in any way, shape or form that anyone was here to make and hasn't had the opportunity to make it. No. Okay. Thank you for that. The Joplin judgment, the member decision not to increase the OAN, and evidence of cooperation with Redbridge and Waltham Forest were the three things to check overnight. Thank you. Thank you very much for your contributions. See you tomorrow, 10 o'clock.